Statement: the Lord Chancellor and Secretary of State for Justice, Secretary Chris Grayling.
Mr. Speaker, I wish to make a statement about the Government's approach to the judgments of the European Court of Human Rights on prisoner voting. This is a subject which provokes intense debate, not least in this House. As the House will know, from as early as the case of Hurst in 2004, the Court found the United Kingdom's bar on prisoners voting to be general, automatic and indiscriminate, and concluded that it was, in the Court's view, in violation of Article 3, Protocol 1 of the European Convention on Human Rights, that is, the right to free and fair elections. The last government committed to implement the judgment and issued 2 consultations which did not resolve the issue. Litigation has continued in the domestic and Strasbourg courts. In the case of Greens and MT in 2010, the Strasbourg court again found that the UK was in violation of Article 3, Protocol 1 of the Convention, and gave the UK 6 months to bring forward legislative proposals to remove the violation. This deadline was stayed pending the UK's intervention in a further case, Scopola, involving the Italian government. In this case, my colleague, the Attorney General, argued in person before the Court that national parliament's discretion to determine policy on this issue should allow for a complete bar on prisoners voting. The judgment in the Scopola case was handed down in May of this year. It concludes the Strasbourg Court's consideration of the issue. In that judgment, the Court made clear that, in its view, the margin of appreciation afforded to individual Council of Europe member states to decide on how far prisoners should be enfranchised was wide, but it confirmed its position that a complete bar was outside that margin. The judgment restarted the clock on Greens and MT and requires the government to bring forward legislative proposals to give effect to the judgment by tomorrow, the 23rd of November, and to enact the required legislation. Mr. Speaker, the Prime Minister has made clear, on the record, his personal views on this subject. I have done the same, and those views have not changed. However, the Government is under an international law obligation to implement the Court judgment. As Lord Chancellor, as well as Secretary of State for Justice, I take the obligation on me to uphold the rule of law very seriously. Equally, it remains the case that Parliament is sovereign. And the Human Rights Act explicitly recognises that fact. The current law passed by Parliament remains in force unless and until Parliament decide to change it. As Lord Justice Hoffman put it in a case in 1999, parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The Human Rights Act 1998 will not detract from this power. The constraints upon its exercise by Parliament are ultimately political, not legal. But the principle of legality means that Parliament must squarely confront what it is doing and accept the political cost. Last month, the Attorney General made clear in evidence to the Justice Committee that it is entirely a matter for government to make proposals, but ultimately for Parliament to determine what it wants to do. Parliament is sovereign in this area. Nobody can impose a solution on Parliament, but the accepted practice is that the United Kingdom observes its international obligations. Mr. Speaker, the judgment requires the government to bring forward legislative proposals for Parliament to consider. It will then be for Parliament to scrutinise and to decide on those. So I have today laid before Parliament a draft bill for pre-legislative scrutiny, and the leaders of both houses are writing to the liaison committees proposing that a joint committee of both houses be appointed to conduct that pre-legislative scrutiny. We judge that pre-legislative scrutiny of this nature is appropriate, given the significance of this issue and the strong views on both sides that exist right across this House. The draft bill sets out 3 different potential approaches for the committee to consider. Presenting a draft bill with that range of options reflects the spectrum of views that we know exist on this question. However, it will of course be for the committee, once established, to consider whether approaches beyond those canvassed in the draft bill should also be considered by Parliament in due course. The first approach in the draft bill is for prisoners sentenced to less than 4 years to be entitled to vote. A 4-year bar has previously been discussed by Parliament. The second approach would limit the vote to prisoners sentenced to 6 months or less. The final approach would effectively restate the current position that anyone incarcerated following conviction would not have the vote. The committee will want to consider these approaches, their consequences if they were in due course adopted by Parliament, and whether there are other options. For example, the Italian system, found to be compliant by the court, disenfranchises prisoners post-release. The committee will, I'm sure, consider evidence on this and other approaches. It may also want to reflect on the consequences for the rule of law and the UK's international standing of Parliament's ultimate decision. The committee might also wish to think about practical implementation, the administrative consequences and costs for the prison service, the courts and electoral registration system and electoral registration officers of different approaches could be significant. The House will want to note that this draft bill does not yet deal with territorial extent. Any bill introduced into Parliament would need to extend to the whole of the United Kingdom, although the bill is currently drafted for England and Wales only. The Government will engage with the devolved administrations during the pre-legislative scrutiny process to ensure the legislation applies correctly in Northern Ireland and Scotland in recognition of the interaction with devolved policy matters. When the Joint Committee has finished its scrutiny, the Government will reflect on its recommendations. We will continue the legislative process by introducing a bill for full debate and scrutiny as soon as possible thereafter. Mr. Speaker, I have set out in some detail for the House the background to the draft legislation that I am publishing today and the respective roles of Government and Parliament in resolving this issue. I commend this statement to the House.